Court dropped a bombshell yesterday in their court case on contraception. To talk about it, they're calling it the Hobby Lobby case. Dr. Mark Goldfeder, he's a senior fellow at Emory University for the study of law and religion in Atlanta. Doctor, thanks for joining us here in St. Louis.
My pleasure. Thanks for having me.
Did the Supreme Court just define what a closely held company is?
It didn't really. It left that sort of open. If you look at the IRS definitions, it probably applies to about 90% of corporations in America. So the law is not narrow in the sense that it only applies to closely held corporations. The ruling was narrow in the sense that it only applies to a very small substrata of those corporations that can pass through the court's level of strict scrutiny.
And it also only applies to contraception, is that correct?
Not necessarily. This particular ruling only applied to contraception. In theory, if there were other similarly positioned, sincerely held religious beliefs, it could apply. What it could not apply to were things like illegal discrimination. The court was very clear that this will not open the door for employers to cloak illegal discrimination behind religious practice.
Okay, what about, say, two gay men come into my restaurant and I don't want to serve them? That's still unconstitutional? I must serve them?
That's still an open question in some other cases, but based on this ruling, the government has a compelling interest to make sure that there is no illegal discrimination, and so this ruling would not affect anything in that regard.
And so why is it discrimination to not serve two gay people, but it's not a discrimination to offer contraception to women?
Well, it's important to take a step back and realize this entire case wasn't about whether or not the women should have access to contraception. The women here are still getting contraception, and they're still entitled to it. The only question here was who's going to have to pay for it. And the court found a way to do this without burdening religious beliefs and without violating the compelling interest and without taking away any employee entitlements. They're just going to have the government chip in and cover it. So no one here is actually losing. That's the difference.
Yeah, because the court didn't seem like the court was really clear about how the women would get the contraception. You're saying government
right.
or...
They left it open. There could be that they would fall under previous religious exemptions like churches had, in which other people would sort of chip in, or there could be incentives for private insurers. But most likely what it comes down to is the government will chip in. Again, we're talking about 4 types of contraception out of a possible 20. 16 of those Hobby Lobby will supply. The ones that they had a religious objection to were just 4 of the 20. Perhaps the government is going to chip in and cover those 4.
Great point. Now, what about there's a company that comes down and says, okay, I'm against the pill, and I'm against some of these other ones that Hobby Lobby's not against because of my religious beliefs.
So it's interesting. This has been the law, the Religious Freedom Restoration Act, for the past 21 years, and Hobby Lobby is the first of its kind to win this kind of case, not because they're evil or because they found a new loophole to exploit, because they had a real claim that managed to pass through all the tests. You know, even if you have a sincerely held religious belief, it won't necessarily get through. You have to prove to the court that it's sincerely held. Then you have to prove that it's actually substantially burdening you. In this case, that all of your owners have the same religious belief, and that would be a real imposition on them to change it or to find some other way to cover it. Then there has to go against the government's compelling interest, and there has to be no less restrictive way. Presumably, in the case that you're describing, there would still be a less restrictive way of having somebody else actually cover it.
It's so fascinating, this study. Dr. Mark Goldfeder, it sounds like you think they got it right.
I think they got it very right. I think the best kind of decision often is the kind that changes nothing, and here all they did was apply the law and find a nice path through which balanced these 2 different values that are in dialectic tension, the right to religious freedom versus the right to an employee's entitlements without anybody actually losing.
This closely held company, these 5 or fewer employees or 5 or fewer owners and all that, what's if an owner changes his mind? And an owner all of a sudden decides, you know what, I don't believe to follow this Christian point of view. I choose to follow that Christian point of view.
It's an excellent question. The court didn't entirely resolve that. In theory, if there was a way to do that, meaning if the owner could be the one who actually signed to pay for it, that might be another way out without anybody losing. However, if the court decided to really push its jurisprudence on the idea that corporations are people and that the entire corporate personhood acts as one, you might still face the same question, in which case you'd go back to having the government chip in.
I read yesterday somebody was making a point that corporations sign limited liability papers, limiting their liability if somebody trips and falls, limits their personal responsibility. And yet in this situation, they want to invoke their personal views. So can corporations have it both ways?
Sure, in the same way that partnerships, and again, if you think of the corporation as a legal person, doesn't mean that it has morality or vitality or empathy. All it means is that it has the right to hold certain rights under the law, to sue and be sued, etc. So it can act in the same way that any other legal entity can. When you have lawyers setting up a law firm, if they want to sign a limited liability contract, they can do that, and the corporation can act just as a juridical person in that sense. So yeah, anything that a person could do in that sense, a corporation can do as well.
Ruth Ginsburg had a 35-page, I guess what they say, a scathing dissent. Anything in her 35 pages that you agree with?
Not very much, in the sense that, a lot of the media, I think, really overread this case. At the end of the day, the Supreme Court did a great job in toning down the rhetoric in the majority and making it really just an administrative case of applying the law. Justice Ginsburg thinks that it's going to be, I think, much more wide-reaching than it actually is. I don't think it's going to change very much at all, and I think the majority was careful to say that our esteemed colleague thinks this is a lot broader than it is, but it's really not. This is really just a very simple case of applying the law and the law working as it should, i.e. finding a path between the different rights and responsibilities that it has to.
Well, the other liberal argument is that this is just the beginning, and all of a sudden now they're going to start using this to invoke all sorts of religious freedoms going forward.
But this is not the first time that argument's been made. In fact, this was really strict scrutiny was the law since 1963. In 1990, the court made that argument and said, well, what if it opens the door to all different kinds of discrimination? And it changed the law in a case called Smith. And then 3 years later, Congress passed the RFRA, the Religious Freedom Restoration Act, putting strict scrutiny back. So really this has been the law for about 50 years. That floodgate has been open for 50 years, and nothing's happened because we really do have a good safeguard. Strict scrutiny really does work.
Dr. Mark Goldfeder is a senior fellow at Emory University Center for the Study of Law and Religion. Doctor, thank you very much. Fascinating conversation. Have a good day.
Thanks very much, you too.
You got it. 6:43 here, Big 550, KT.